Good afternoon, everyone. My name is Bahey Hassan, Director of the Cairo Institute for Human Rights Studies. Thank you very much for joining us today. It is my pleasure to moderate this discussion on the Egyptian government's weaponization of counterterrorism laws to silence human rights defenders. Of course, it is not limited to human rights defenders. A few years ago, in 2017, a US Congressman, Tom Malinowski, testified before Congress on the human rights situation in Egypt, given his former position as Assistant Secretary of State for Democracy, Human Rights, and Labor. In his testimony, Congressman Malinowski wondered if the young men who were rounded up, executed, and passed off as terrorists killed in action in Egypt were in fact terrorists. The truth is that we know for a fact, given documentation by human rights NGOs, that many of those victims are innocent civilians. Not less important, counterterrorism has become a primary tool for the Egyptian government to get rid of its opponents and the dissidents, and to keep them behind the prison bars for years without trial or even an interrogation. Those held under terrorism charges include peaceful secularists, Islamists, and Christians as well. Journalists, academics, Palestinian and human rights defenders, lawyers, former parliamentarians, and the medical doctors criticizing the effectiveness of the government response to COVID-19. The list also includes businessmen. The most popular football player in Egypt, and the ultras, I mean the mass football supporters groups, and even former diplomats, I mean colleagues of Egyptian diplomats in Geneva, who are now behind bars on false terrorism charges. I myself was sentenced in Abyssinia for 15 years in prison by an Egyptian terrorism court circuit. And the evidence against me includes moderating a side event held at the United Nations Human Rights Council, just like this one. The significance of today's discussion, however, is not only limited to Egypt. It also concerns how Egypt's model is being adopted in other countries. The absence of an effective international response has made the Egyptian government's record in manipulating counterterrorism a model to be replicated in other countries. The most recent example is Algeria, which over the past months started following Egypt's footsteps in targeting peaceful dissidents behind the smoke screen of counterterrorism. I am honored to be joined today with 4 distinguished speakers. The first speaker, Ms. Fionnuala ni Aoláin, the United Nations Special Rapporteur on the protection and the promotion of human rights while countering terrorism. Second speaker, Mr. Brian Dooley, the senior advisor to the United Nations Special Rapporteur on Human Rights Defenders. Third speaker is Mr. Saeed Benarbia, the director of MENA program at the International Commission of Jurists. The fourth speaker is Ms. Celine Chaz, Human Rights Defenders. Celine is currently coordinating a global campaign for the release of her husband. Her husband, Rami Chaz, is Egyptian-Palestinian human rights defenders and now a prisoner of conscience in Egypt since 2019. Every speaker would have between 7 to 10 minutes, and then we would open the floor for discussion. Please, Ms. Fionnuala.
Good morning, good afternoon, good evening, everyone, depending on where you're joining us. I'm really pleased to join this side event on behalf of the mandate of the Special Rapporteur on promoting and protecting human rights and fundamental freedoms while countering terrorism, extending the long collaboration that my mandate has had with the mandate protecting human rights defenders. We have a lot of work and a nationality in common. We're all Irish. But also a long collaboration with the Cairo Institute for Human Rights Studies and also the International Commission of Jurists. So we're very, very glad to be here. It's a really, really good day to have this conversation because as we are talking today in Geneva about the misuse of counterterrorism and its misuse against human rights defenders and civil society actors around the globe, in New York, at the same time, states are about to adopt, likely today, the global counterterrorism strategy, which is the strategy that sets the standard, the tone, the guidelines for how states are supposed to engage in countering human rights, countering counterterrorism while upholding human rights. And one of the things that's really clear as we adopt this strategy is that we're also 20 years on from the events of 9/11. And in that 20 years, what we have seen is a global misuse and abuse of counterterrorism by multiple governments. And my mandate since its creation in 2005 has systematically documented the ways in which states have used counterterrorism, security, and increasingly extremism and violent extremism or radicalization language as a cover for silencing those who oppose them, for locking up those who disagree with them, and for clamping down on the fundamental human rights that in fact are the best conditions, the best things that actually prevent terrorism occurring in the very first place. And so one of the things I want to stress is, as I make some remarks about the global landscape that we're in, is that the trend line for 20 years has been overwhelmingly negative. We've seen a number of normative changes and a normative expansion of counterterrorism, particularly in New York through the United Nations Security Council. The Security Council has taken on a massive effectively a legislative role on counterterrorism, which has given cover to and enabled state repression at the national level. That repression stems from a number of things. First of all, it stems from national counterterrorism legislation. And I want to say that one of the things that's extraordinary about this post-9/11 landscape in which Egypt also and many countries sit is that it's a perfect gentleman's agreement because everybody legislates for terrorism, but there is no globally agreed definition of terrorism. And as a result, every state gets to define whomever they like in the box of terrorism, with no meaningful oversight, no meaningful human rights accountability, and no meaningful penalties when we see systematic abuse. The second thing we've seen in the last 20 years is the legitimacy and the permissibility that counterterrorism language gives to states. So the very invocation of the word terrorism is like an immunity charm. It is as if by using that word, states feel they get to do what they want to do with no cost. And one of the things that's so important about this side event, but also so important about what we're seeing in New York today, is a global awakening to the systemic abuse of counterterrorism law and practice. The other thing I would just stress that we see globally is a massive expansion of the architectures of counterterrorism, the spaces in which states get to function and use counterterrorism language and practice as cover for what they do. And one of the reasons why this twofold normative plus architecture is so distressing is because one of the things that those architectures and those normative changes do is they function to quash and in many ways disabuse the capacity of civil society to function at all. Because much of the counterterrorism law and practice we see around the world is specifically aimed at civil society. A couple of years ago, my mandate issued a report to the Human Rights Council where I found that 66% of all communications from the mandate involved the use of a counterterrorism measure against a human rights defender or a civil society actor. So let's be clear about two things. One, that's really lousy counterterrorism, because if you are targeting civil society, you are not securing your society, you're disabling your society from functioning. And the second is that, of course, it's a breach of our most fundamental human rights as protected by international law. So what do we need to do now? At the global level, as we're seeing in New York, and we're actually seeing for the first time, in my view, the emergence of a really robust counterterrorism strategy that is recognizing for the first time in the last 20 years that we have a systemic problem with the abuse of CT. The second thing we need to learn is that this is not an accident or a bad apple problem. The misuse of counterterrorism is embedded in the practice of national legal systems. And that abuse is part of the DNA of state practice in many countries. So let me focus on what my mandate has had to say, particularly in relation to the country that we're talking about today and the experience of human rights defenders in Egypt. And I do want to acknowledge that while I'm going to speak about a number of the communications that I have issued to the Egyptian government, many joined by my colleagues, including human rights defenders, we continue to have a robust, respectful engagement and a significant concern and articulation of that concern back and forth with the government. And I hope that we can continue to engage in that robust and much necessary conversation with a move to remedy and action. So let me talk a little bit briefly in my closing minutes about the legislative structure for counterterrorism in Egypt. As many of you know, the mandate I hold has issued with a number of other special procedure mechanisms, a number of communications concerning counterterrorism legislation in Egypt. In February 2020, both I, the Working Group on Arbitrary Detention, the Working Group on Enforced and Involuntary Disappearances, and a number of other special rapporteurs issued our deep concerns about the adoption of the Terrorist Entities Law and the Anti-Terrorism Law, both of whom also have a web of relationship with a number of other legislative enactments, including the law that regulates peaceful demonstration, as well as the law on associations in Egypt. And one of the things I would stress from a regulatory point of view is just how enmeshed and dense the security law system is, and how difficult as a result it is to ensure remedy and access to protection for human rights defenders as a result. In respect of those laws, I do want to stress the key points that my mandate and others have communicated to the government. The first is that we are deeply concerned that the definition of terrorism and the definition of extremism in national law is overly vague, it is imprecise, and the result of that is that it leaves open the possibility for systematic abuse of the law and its use against ordinary citizens, journalists, and NGOs. The second thing I would stress is that we have been really highly concerned that the use of these laws has a huge overlap with a number of other fundamental human rights violations. And there, I particularly want to stress the challenges of enforced disappearances. And in particular, one of the major concerns I have is that the anti-terrorism law effectively codifies enforced disappearances by allowing individuals to be arrested and held for up to 7 days incommunicado before they can be questioned by a prosecutor. In addition to that, we see the targeted and systematic use of these laws against human rights defenders. Precisely because of this broad definition of terrorism, a range of activities that are actually fundamentally protected by international law, the right to say what you think, freedom of opinion, the right to associate, the right to political participation, all of these fundamental rights are essentially caught by the application of the counterterrorism law. I think the other thing that I would want to stress about not just the sort of the legislative framework is to be clear that that legislative framework is inconsistent with international law. It does not meet the standards of the International Covenant on Civil and Political Rights, the Universal Declaration on Human Rights, but also, in my view, as I've expressed very clearly to the government, it's inconsistent with the Security Council resolutions regulating terrorism. When we target civil society actors and human rights defenders using counterterrorism law, not only are we not making a society safe, because we're profoundly misusing and undermining the idea that security can be advanced by fair and proportionate law. But more than that, I think we continue to create the conditions conducive that produce anomie, disaffection, violence in so many societies. And so I will pause there by underscoring that the special rapporteurs who have looked closely, led by my mandate, at the systematic structure of counterterrorism law in Egypt, have continued to undermine the fact that that law is inconsistent with Egypt's international law obligations. And that in particular, its misuse and misdirection against those who are protected by international law continues to be of deep and profound concern to us. So I'll pause there. Thank you.
Thank you very much, Fiona. And thank you, of course, for the great job you are doing in your day-to-day acting as a special rapporteur on this very important issue. Second speaker is Mr. Brian Dooley. Please, Brian, go ahead. You have 7 to 10 minutes. Thank you.
Thank you very much, Bahey, and thanks very much, Fionnuala, too. I'm an advisor to the Special Rapporteur on Human Rights Defenders, Mary Lawler, who sends you her apologies for not being able to join us today, and her greetings too. This mandate was set up 20 years ago, and like Fionnuala's mandate, has charted over that time the very similar trajectory that Fionnuala notes there of the misuse year on year of counterterrorism laws to target human rights defenders. I recently looked at all of the recommendations made by all of the previous mandate holders over the last 20 years to states, and there is a depressing commonality. If you look back 5 years or 10 years or 15 years or even 20 years, you will see this mandate recommending to states they stop doing this, that they stop using counterterrorism measures to silence and target human rights defenders. In one sense, in Egypt, of course, as many of you know, it predates 9/11. You know, many of the amendments under Mubarak of the early 90s were, as I understand it, amendments to the 1937 Penal Code, but then President Sisi brought in new terrorism legislation to enable further targeting of defenders in 2015. And as Fionnuala points out, many of parts of the legislation in various countries we see are very similar to each other, whether there's actually cut and pasting going on, or it's less direct than that, but we see very similar provisions, very vague, overbroad terms of what might define terrorism. And basically, many states just decide to define terrorism as vaguely as is convenient for them. Harming national unity, disrupting general order, these sorts of things, which are also sorts of terms that are included in Egyptian legislation, are exactly the sorts of terms which we see in country after country. One of the variations in Egypt, as Fionnuala also pointed out, a close association between the use of these counter-terror laws and disappearances. Many of the human rights defenders we've seen in Egypt also experience disappearance and torture. And also in Egypt, which we don't see in many other countries, just the sheer scale of this, the overwhelming numbers where human rights defenders are lumped into other mass cases with dozens and sometimes more than dozens of other people in the same case. And of course, too, in Egypt, we see the recycling of people in pretrial detention, where they're supposed to get a trial after 2 years, and then when they don't, they're just another charges are lumped on them, and they can be held then year after year after year. This mandate has, since Mary began just over a year ago, raised these cases half a dozen times, some in association with Fionnuala and other mandates too, with the Egyptian government. And I'd like to make a few observations about how the Egyptian and other governments use this counter-terrorism legislation. And really, in one sense, it's sort of a charade, right? They know, the Egyptian government, the Egyptian authorities know that these people, these human rights defenders, are not terrorists. And we know that they're not terrorists. And they know that we know that they're not terrorists. But despite that, despite winning the argument, if you like, they still manage to put defenders away, sometimes for a very long time. The next report from this mandate is going to be presented to the UN General Assembly in October, and it will concentrate on the long-term detention of human rights defenders across the world. And most of the time, in most of the cases we see of people, defenders who are sentenced to or liable to be sentenced to 10 or more years in prison, the relevant authorities, the relevant government uses some sort of anti-terrorism, national security, treason type laws to give itself permission to put somebody away to put a human rights defender away in prison for 10 or more years. If the intention, which it is to silence human rights defenders, to shut them away, to intimidate others, and to lock them up for a very long time, then you need a serious sounding pretext to do that. You can't, with a straight face, put somebody away for 10 years for being late back with their library book, right? You have to invent some pretext, and terrorism is the most convenient one for many governments to reach for, including the Egyptian government. I won't repeat what Fionnuala said. You know, our mandate has seen many similarities to what Fionnuala has found in terms of the global expansion of these sorts of laws. I would say that the position is, it's very hard when a human rights defender is charged with terrorism. It's not hopeless, but it can be very hard to to get any sort of redress or to get somebody out of prison once they've been taken. Now, we saw from Egypt, it can be done, an enormous effort in the end of November last year, in early December, where the 3 defenders from EIPR were released. I know the charges haven't been dropped. But it can be done if there is enough international attention. It sometimes can work. Yesterday in Burundi, the human rights defender Jermaine Rukuki, who had been sentenced to 32 years in prison, again for disrupting internal security, this sort of made-up charge. After an enormous amount of international pressure, his sentence was reduced from 32 years to 1, and he'd already served more than 1, so it looks like he's about to go free. But we are under no illusion of how difficult it is to come up against countries and even to get to secure the release of individual human rights defenders. One other observation I'd make too is that while governments clearly give themselves the power very effectively to put human rights defenders away in prison for a short term or sometimes for a very long term, I think the impact of smearing a human rights defender as a terrorist has lost some of its force. Compared to 20 or 30 years ago, and I don't want to overgeneralize, but compared to 20 or 30 years ago when a human rights defender was accused of or even convicted of terrorism by a government, I think some of that vilification and some of that smearing would sometimes discredit or give pause to thought for a defender. Now it's so standard, it's so overused, it's so meaningless to throw that charge at a human rights defender that I think it's lost some of its force. Now, I know that doesn't mean that the defenders don't end up in prison, but in terms of throwing that accusation to try and discredit, I think it's lost much of its value now. The other thing I'd say too is that Mary Lawler and her predecessors were appointed for their expertise on the issue of human rights defenders. Member states, UN member states, gave her and before her the others this mandate to advise them about human rights defenders because they understood, they had great experience and they really understood the issues. And one of the reasons that Mary was given this mandate is because she knows who a human rights defender is and who isn't. She knows the difference between a terrorist and a human rights defender. And so when she goes to states and says, you gave me this mandate to tell you who's a human rights defender, and I'm telling you, Bahey is a human rights defender. The Mahanoa is a human rights defender. You've asked me to advise you, and I'm telling you. Then states have very little response. But again, it's one of those situations where you can win the argument, but it doesn't change the power dynamics, and it doesn't mean that we can stop people being targeted. We know how very difficult this is, and to be frank, the more I listen to Fionnuala, the more I realize really what we're up against. I mean, this isn't just a few bad apple countries. It's not even just a few bad apple countries who are coordinating with each other. I think this is increasing and expanding, but this mandate will continue to press for the release of human rights defenders who've been put in prison under counterterrorism legislation on that pretext, and continue to try to protect others from being targeted with this. So I'll leave it there. I've got 1 or 2 more other things to say, but I think I'll save those for the questions and answers. Thanks very much.
Thank you, Mr. Brandoli, and of course, thank you as well to the Special Rapporteur on Human Rights Defenders. I am sure that you are doing a great job and a great asset for her as based on your long experience as human rights defenders. Third speaker is Mr. Saeed Benarbia, but I would like to draw to your attention in relation to question of translation. to listen to the meeting without simultaneous interpretation, please click on the interpretation button at the bottom of the screen and select off. للاستماع باللغة العربية اضغط على زر الترجمة في أسفل الشاشة واختار
the Arabic language. Just click on the English channel stage. You have the floor.
Thanks so much, Bahey, and thanks to the other speakers. I will focus my intervention on the trumped-up charges, the abusive prosecutions, and unfair trials that human rights defenders face in Egypt in the name of combating terrorism. And let me just start by giving some names of who are these human rights defenders. It will be difficult to address all cases, of course, but I will just give some few examples. These human rights defenders are Noor al-Masri, for example. She was arrested on September 2019, charged by the state security prosecution with participating in achieving the goals of a terrorist group. Mohammed al-Baqir, director of Adaala, an independent NGO, arrested on September 2019, charged by the state security prosecution with joining and funding a terrorist organization. Amr Imam, a lawyer with the Arabic Network for Human Rights Information, again arrested on October 2019, charged by the state security prosecution with aiding and abetting a terrorist organization. Huda Abdel Monaim, human rights defender and former member of the National Council for Human Rights, arrested on November 2018 and charged with joining a funding terrorist organization. Ibrahim Mitwalli, coordinator of the Association of Families of the Disappeared, arrested in 2017 and charged with membership in a terrorist group, and charged again in 2019 in another case with membership in a terrorist group. Ala Abdel Fattah, arrested in 2019, charged by the state security prosecution with joining and funding a terrorist organization, still under pretrial detention. After he was arrested in 2019 after spending 5 years in jail for terror-related charges. Ibrahim Azzeddin, researcher with the Egyptian Commission, arrested in June 2019, charged by the state security prosecution with membership in a terrorist group, and charged again in 2021 with membership in a terrorist group. These are just few names, few cases amongst hundreds and thousands of people who are facing trumped-up charges and abusive prosecutions in Egypt in the name of combating terrorism. Why abusive prosecutions? Because in most of the cases documented by the ICJ, state security prosecutions has consistently failed to even name the terrorist organization or group that the detainees have perpetually joined, or provide any evidence that they funded or contributed to funding, or aided or abated or contributed to achieving the goals of such groups. The charges and prosecutions are typically based on National Security Organization report, to which neither the accused nor the lawyers have access. In most of the cases, prosecutions have been initiated with the sole purpose of intimidating and silencing human rights defenders as human rights defenders, but most importantly, as witnesses of human rights violations. Prosecuting individuals despite a lack of evidence to support the charges is contrary to both the Egyptian and international law and standards, but it's not only at the level of prosecution. Even when cases are referred to trial, judges in Egypt continue to fail to dismiss cases where there is a clear lack of evidence to support the charges against the individuals being prosecuted. In addition to these abusive prosecutions, there is also a presumption in favor of pretrial detention that both prosecutors and judges apply. Most of the cases I refer to, and some of the people that I refer to were arrested in 2017, that they are still being under pretrial detention in what is now called a new technique developed by the Egyptian military, Egyptian government, and complicit criminal justice system in what's called tadwir. Tadwir is a new technique through which, when human rights defenders are being under pretrial detention for almost 2 years, instead of releasing them, the prosecutors will just bring new charges under new cases and refer these these detainees to and maintain these detainees under pretrial detention. There is no need for evidence that these individuals committed any kind of criminal conduct. There is just a need for prosecutors, based again on reports from the State Security Organization, to maintain these individuals and maintain these human rights defenders under pretrial detention, sometimes for more than 4 years. Under international law, and I think Fionnuala mentioned that, it's clear that individuals' pretrial detention should not be mandatory for all defendants charged with a particular crime, including terrorism-related crimes, and it should be decided based on the individual circumstances of each case at hand. In and of itself, pretrial detention in Egypt right now become a sentence, and judges and prosecutors are willingly condoning practices that violate the rights of human rights defenders and the rights of detainees to security of person and to freedom. When the few cases that are referred to trial, and not few cases that are referred to trial, there are two techniques. One is just maintaining human rights defenders under pretrial detention without referring to trial. But when cases are referred to trial, there are consistent failure by the Egyptian judiciary to ensure compliance with international fair trial standards, including the right to respect the right of counsel and to ensure adequate time and facilities to prepare a defense. According to information that ICG was able to document, including through interviews with lawyers, at least 19 lawyers told the ICJ over the past 2 years that they are unable to represent detainees before the state security prosecutions, and that their ability to represent clients is severely restricted by the security services and by the prosecutors themselves. In one case, one of the lawyers said that you assist a detainee or a human rights defender or detainee, but you have no guarantee that you will be able to leave the office of the prosecutor free. In the specific case of Mohammed al-Bakr I mentioned, while he was representing and defending Ala Abdel Fattah, another human rights defender, prosecutor informed Mohammed al-Bakr, a lawyer and human rights defender, that he himself was also under prosecution and was under arrest, and he himself also was accused of terrorism-related charges. There is a failure from judges to ensure presumption of innocence or equality of arms or right to be even present during hearings. There is harassment and intimidation of lawyers for discharging their duties. And again, in the specific case of al-Bakr, he was told that legally representing individuals belonging to a terrorist group is a key to funding and providing material terror support to such a group. So these are just some of the observations and remarks about the abusive use of terrorism-related charges to target human rights defenders through abusive prosecutions and unfair trials. There are also some developments related to the recent amendment to the terrorism law that were introduced in 2020, and that provides or give the Office of Public Prosecutor, State Security Prosecution, the possibility to demand court to place human rights defenders in terrorist lists. First case was documented in April 2020, in which lawyer and human rights defender Ziad Al-Alimi and 20 other individuals were placed on the terrorist list for 5 years. To link it to what Fionnuala was saying about the global counterterrorism strategy, any country like Egypt that has a well-documented record of abuse and misuse of counterterrorism measures to crush dissent, to target human rights defenders, to crush civil society, any country with such record should have no role in developing any initiatives by the UN or any approaches to how to deal with counterterrorism or terrorism in general. And I think it's important for states to act individually and collectively to ensure that Egyptian government that turned Egypt into an open-air prison in which any and all forms of free expressions are crushed has no role in developing such a process at the UN. Thank you.
Thank you very much, Mr. Saeed Benarbia, and in particular to your final recommendation in this round of debate. I would come to you in particular with a follow-up question when we open the floor for questions and answers. But now I invite Ms. Celine Chas to present her presentation for today's discussion. Ms. Celine.
Hi. Thank you. So my name is Céline Lebrun-Chas. I'm a human rights defender myself, the wife of Rami Chas, an Egyptian Palestinian human rights defender who is currently detained in Egypt since July 2019. I was myself deported illegally at the time of the arrest to France, and I've been from France campaigning for his release. I want to start by saying that I'm not pleased to be here. I should not be here. Today is Rami's 50th birthday. The second is spending in prison. Today I should have wake up and tell him those three simple words: happy birthday, Rami. I've been deprived of this right when heavily armed, black-cladded men stormed into our house on this night of the 4th to the 5th of July 2019 and took him away from me. I should be throwing a surprise party for him and showing him how special he is for me and for us, his family. Rami is a human rights defender, an Egyptian Palestinian born in Lebanon. Very young, he made his fight, the fight for freedom and justice in his countries, and decided to defend political and human rights for his people. Due to his activism, he was harassed for several decades until his arrest finally 2 years ago. And his story is has many of the elements that each of you shared and recalled. He was arrested in the middle of the night without any warrant, without even any explanation. Any word was given to us. He was forcibly disappeared for 36 hours. We didn't know where he was until he reappeared in front of the state security prosecution to be interrogated without having been able to call his lawyer or his family. By chance, a lawyer was there and was able to attend his interrogation and to tell us his whereabouts. His interrogation was all about his legitimate political activities. Did he participate in the January 2011 protests and the June 2013 protests? For whom did he vote over the past few years? Absolutely no question was asked in relation to the case we discovered he had been added to, and that's known under the Hope case. Charges that he's facing today are all related to counterterrorism. First one, belonging to a terrorist group. And as it has been said, at no point until today, this group has been mentioned or named. We don't know to what terrorist group Rami is supposed to be belonging. He is accused of spreading false news. We don't know which news, we don't know where he's accused of having spread those news. And finally, the last of this cocktail of charges faced by so many in Egypt, attempting to disturb the peace and security of the regime. To that day, until today, we haven't been able to see the investigation, the state security investigation file based on which he is supposed to be detained. Neither us, neither his lawyer, neither him. His detention, his pretrial detention, has been renewed 24 times in 24 months. Sometimes he hasn't been able to attend. Sometimes he hasn't been able to speak. Sometimes he hasn't been able to even hear or understand what was happening because he was held in a glass cage that's soundproof. He hasn't been able to have a proper conversation with his lawyer in a context of intimacy since more than a year. Finally, in the last escalation against my husband, last April 2020, he was added alongside former member of parliament and human rights defender Ziad al-Alimi to Egyptian so-called list of terrorist individuals and entities. In absentia, neither he or his lawyer were informed that such a procedure had been opened. They were not interrogated by the judge. A judge that, when we appealed the decision a year later, when we were finally allowed to present a defense against this accusation, the judge seemed surprised. How come we haven't heard him? Why? Because normally this terrorist list is supposed to be used to target people who are on the run, people who are not there, who are not present. It's not meant to target people who are actually detained and could be called on and interrogated at any time. We are still waiting today the decision of this appeal. The decision has been postponed 3 times over the past 4 months, and there is no end in sight as to when we're ever gonna know if we won or if we lost this appeal. This appeal could have terrible consequences for him and for my family. If his name remains on this list, he will be deprived of his passport. He will be deprived of his political and civil rights, and our family will remain separated, myself in France and him in Egypt. Over those past 2 years, there has been an incredible mobilization that's growing every day. As we speak, people are rallying around the world in major cities. There has been rallies in Madrid, in Brussels, in Paris, in Ramallah, and there will be one later today in Washington, calling for his release on such a special day as his birthday, and only 12 days before the end of the 2 years of detention allowed by Egyptian law. 2 years of pretrial detention, pending investigation. How can this even be legal? And an investigation that is not even happening because, again, my husband has not been interrogated once to respond of the accusation brought against him, and at no point any proof was ever presented. And we're only 2 days before many other human rights defenders like Ziad al-Alimi, Hassan, Hisham Fouad, and others detained in the same case as Rami will also reach the end of these 2 years. Listening to you, I don't know if I should feel hopeful to see such brave and courageous people advocating on behalf of my husband and prisoners of conscience in Egypt and for a better use, a lawful use of counterterrorism laws, or if I should feel sad and depressed to see that this has had so little impact so far. So I'm not sure what I should be calling on you to do. Definitely to continue what you're doing, and definitely to do everything that's in your power to make sure that Egypt finally listen to your voices, to the voices of the UN Working Group on Arbitrary Detention and the special procedures that's been calling for my husband's immediate and unconditional release, that's been to all the human rights, to all the organizations defending human rights like Amnesty, FIDH, Cairo Institute, ACAT, EIPR, Freedom Initiative, and so many others who've been advocating for the same thing. to listen to the over 100,000 people who've signed today a petition across the world calling for my husband. So I hope that finally the Egyptian authorities will hear this call and free my husband and all political prisoners in Egypt who should be looked at as a wealth for this country. They are the future. They are not a threat. Dissent is not terrorism. Dissent is the vibrant heart of democracy, should be cherished and protected. Thank you.
Thank you very much, Celine. Anyway, regardless this desperate situation, I wish for Rami a happy birthday, and I am sure that you would meet soon. Thank you very much for all the speakers, and the floor is open for questions. There are no questions. I don't see hands are raised. As I raised before, I have a question to Mr. Saeed Benarbia, and I invite also other speakers to, if they would have more reflections on the same questions. Mr. Saeed Benarbia used a very telling expression: abusive prosecution. From the presentation you made, and in fact, also the other three presentations, how you can describe the state of Egyptian judiciary today? This is, as far as I understand, this is the core mission of your great institution, the ICJ, the International Commission for Jurists. So how, from your presentation and I invite also the other three distinguished speakers to reflect on how they see the state of Egyptian judiciary now, because those human rights defenders and the other hundreds of peaceful dissidents, they are not in jail just by security decisions. No, it is blessed by whatever judiciary institution, whatever the prosecution or a court decision. Please, the floor for you, Saeed.
Thanks, Bahey. Thanks so much for the question. As ICJ, we believe that the Egyptian judiciary right now, or over at least the past 7 years, has been playing a role as a tool of repression, not as an independent arbiter of justice, not as an institution that should act as a check on the military and on the government. This is the judiciary, the office of the prosecutor, ordinary courts, state security courts, military courts are all a part of a system that is being docile in the hands of the government and in the military in implementing a sustained, relentless crackdown on human rights and the rule of law, and abdicating its responsibility in protecting rights and in acting as a check on the government and on the security services. The abusive prosecution, we were talking just about the situation of human rights defenders, but there are also other cases involving terrorism-related charges in which mass death sentences are pronounced by the military without respect to any guarantees of fair trials. Sometimes sentences are pronounced after 30 minutes, 1 hour proceedings, in which the court did not even hear all the names of the accused. Fair trial violations are documented at the pretrial detention level and at the trial level. And I think fundamentally, the judiciary has always had some subordination to the executive. Subordination over the past few years, it's just become complete. And unfortunately, while the justice system has been used as a tool to crack down on fundamental rights and freedoms, it has also played another role, which is to shield state officials and security services from accountability. Just a few days ago, the decisions on death penalty in the Rabaa case were upheld by the cassation court. Yet until today, and after more than 1,000 people killed in the context of this person, the Rabaa sitting, there is no single official who has been prosecuted or held to account for the crimes, unlawful killings that were committed during the dispersal of the sitting. So it's two levels. One is implementing the military and the government's crackdown on fundamental rights and freedoms in the one hand. In the other hand is shielding state officials and security forces from accountability when they are responsible of human rights violations and crimes under international law.
Thank you very much for Saeed. Will any other speaker would like? Brian, please.
Just very quickly, I think that makes a lot of sense. Sadly, what Saeed says, and you know, one of the pushbacks that this mandate gets a lot when it raises cases of defenders being targeted by various governments, including the Egyptian government, is, you know, we cannot interfere with an independent judiciary. We don't control our judiciary. You're complaining to the wrong people if you're complaining to the government. But I think where we see criminal justice systems which clearly are not independent, then we have to say so. And I'd say in the case of the Egyptian judiciary, it's not a case that it's a dysfunctional or malfunctioning or incompetent system. Actually, quite the reverse. It's now become a very efficient machine to target and imprison human rights defenders. And I don't quite know how big that shift is. I know from years ago, it wasn't always ideal, but it does seem to be different now, that it looks completely dependent on what the government wants in terms of targeting civil society.
Thank you very much, Brian. Ms. Fionnuala.
Thank you. I think one of the really key things to understand is that counterterrorism law is a form of exceptional law. It's an exceptional legal system. And exceptions essentially in so many contexts historically, but also contemporarily, they really destroy the fabric of the rule of law from the inside out. And I think this has been particularly true in the context of Egypt, where not only have we had decades of permanent states of emergency, the consistent use of exceptional law as the norm, but the reliance on counterterrorism law to essentially do a kind of a exceptionality normalizing the management of dissent or disagreement or political participation within a state. I think what I would underscore is the importance of maintaining the resilience of the judiciary, because at the end of the day, in most legal systems, they are our fundamental bulwark against tyranny, and they are the central body that has the capacity to push back against the overreach of states. And many states overreach all of the time. One of the few effective mechanisms we have are the capacity of judges to push back. And I don't think we should underestimate the fear of judicial officers and others in highly exceptional systems to engage in that kind of pushback. But I also think we have a role in encouraging them to do so, because I think you won't remake systems overnight. And sometimes judges need to find their spines, and they need to be reminded of the fundamental oaths that they take as lawyers, as officers of courts, to the law. And this is where I think international associations of judges and lawyers are really important, because in general, at least every judge I know really cares about his or her reputation. It matters to them to be a symbol of legality within their legal systems. And so I think we often tend to put pressure on governments, as we should, but we should also remember that it's important to identify the judges and point out who precisely are the handmaidens of the work that's being done, the exceptional work that's being done within the state. The other thing I would just stress is that one of the challenges we do see in the Egyptian context, I think, is that the kind of formal role of judge in the system, I think, has in many ways also been sort of pushed aside by the role of the Supreme State Security Prosecution. And the fact that these other officers, including those responsible for prosecution, are functioning in de facto judicial roles is also an egregious kind of breach of the separation that ought to exist between the judicial branch and the prosecution branch. So that is a footnote, but a really important one in terms of what's, I think, happening day to day. I'll stop there.
Thank you, Ms. Manilla. Ms. Celine, do you have, would you like to share? Okay. I would pass the floor for Kilimon from the delegation of Germany. Please, the floor is yours.
Hello, good afternoon. I think the camera is not working, but I hope you can hear me.
We can hear you fine.
Yes, we hear you.
Thank you. Thank you very much. I'm Clemens from the Permanent Mission of Germany in Geneva. I wanted to thank you for this event, to the organizers of the Cairo Institute, other NGOs, but also special procedure representatives. It's a very important input to have in an event like this. And we share many of the concerns that you have raised. And we've raised them both in private and in public regarding the situation for civil society. An active and vibrant civil society is a fundamental requirement for long-term stability and prosperity. And there must be criticism allowed of the government. There are some positive steps, such as the recent release of people who have been detained, but still we also remain concerned about how the NGO law would be implemented. And maybe something that was not raised much today is the number of executions that has raised, or that has grown quite significantly over the past years. So I just wanted to pass on this message. I wanted to thank you again for having this event and providing input that will shape also the way we look at the situation in the Human Rights Council and beyond. Thank you.
Thank you, Mr. Clemons. Would any of the four speakers would like to respond?
Can I just make a comment about the kinds of patterns that we see? So one of the things that I think is really, and my appreciation to Germany for their remarks and the attention given to this issue, because I think it fundamentally concerns all states when states misuse security powers, because the whole notion of a security that is embedded in the UN Charter is a security that protects all equally, a security that's bounded by and framed by human rights. And so when states essentially move out of the compact with one another by abusing security practices, they actually undermine not only the security of their own population, but actually the broader consensus around the value and necessity of security, which is bounded. And I think that's a very, very dangerous thing when that happens. And so I think this is one of the challenges we see beyond the micro of any particular state, just the broader illegitimacies and tensions that it creates when we see abusive practices or systemic abusive practices. The other thing I would just say that we definitely have to, we've seen this already, I think, in the comments made by Saeed and Brian, is that counterterrorism law doesn't come, it's sort of a package. And the package has a number of elements. One is extensive pretrial detention with the kind of evacuation of the most fundamental of rights. It's a form of preventative detention is a very useful device for states because it is simply, it's an avoidance of law, essentially, and that's systemic and embedded in misuse of CT. The other piece, though, is at the other end of the spectrum, which is invariably, and this I think is true in the case we're looking at today, is we see it not only extended sentences, but layering of sentencing. So individuals are subject to tariffs and penalties that are entirely disproportionate to either the evidence or the charges that are being laid against them. And that's a consistent feature, I think, of the work that the HRD mandate has been illustrating in these cases. And of course, the use of the death penalty. We see a systemic coupling together of death penalty charges and death penalty use in security type cases. And again, given the tenuous nature of charges in the first place, the lack of legality to so many of those charges, the lack of due process, again, the egregiousness of the use of the death penalty in contexts where all of the other fundamental rights that we have in place to protect the right to life being egregiously abused are absent in these cases.
Thank you, Ms. Fionnuala. The floor for Ms. Laura from the Mission of United Kingdom, please. Ms. Laura or Laura? Okay, go ahead. Please unmute yourself.
We can't hear you, Laura.
Yeah, I saw the name without her picture, but
Oh, she sent a message on the chat, but we can't hear you, Laura, if you can hear us.
yeah. Okay, the floor for Mr. Hassan Bayoumi from Amnesty International. Please, Hassan.
Thank you, Mr. Bahey, and thanks everyone for your interventions, very useful. So I don't have much to add to what you said, but maybe to pick up on one issue that the Special Rapporteur has raised on the layers of use of counterterrorism is that what we are increasingly seeing is that the National Security Agency is playing a bigger role in deciding and overriding decisions, even by prosecutors, even by the Supreme State Security Prosecution, even by terrorism circuit courts judges when they order the release of detainees pending investigations, and even by courts when they convict people and after they have ended their sentences or even acquitted. At the end of the day, what we found that in political cases, basically most people that are supposedly released by judicial decisions, they have to wait for the NSA signal, the National Security Agency approval. If they fail to get that signal, they will not be released. They will stay there as long as the NSA signal has not arrived. And if the signal is negative, then you see the pattern of rotation, which Mr. Said has described earlier. So we are increasingly seeing the role of that executive body acting in that extrajudicial manner, and it doesn't just stop there. I mean, it goes further to another pattern called NSA surveillance and NSA summons, where even if people are released, we found that activists, human rights defenders are targeted by the NSA through this regular surveillance. It's not police probation, but they actually have to report to the NSA. They have to report to police stations without any judicial decisions or any way to challenge the legality of these practices. Likewise, human rights defenders that are doing the work and hasn't even been arrested, they are subjected to these intimidation tactics, which makes them, I mean, it has led many to leave the country. It has led many to take dangerous routes to leave the country even, and it has led many to self-censor or leave for fear on their lives, on their freedom, and on the freedom of their friends. So it's really, as Special Procedures has described, as a package. And I'd say it's used to repress really political opponents and critics.
Thank you very much, Mr. Hussein Bayoumi. Would you please try again, Ms. Laura from the Mission of United Kingdom, and unmute yourself?
I believe we have lost her. She's not logged in anymore.
Yeah, okay, okay. I don't see other raised hands or participant asking to take the floor or new questions. So I would ask the speakers for their final comments. Every speaker would have 3 minutes for final comment. We'll go in the same order, and we start with Ms. Fionnuala, please.
Thank you. I would just stress we're at a pivotal moment. It is right to say that many countries, including Egypt and others, have had long histories of the use of counterterrorism that predate 9/11. But the events of 9/11 catalyzed a way in which counterterrorism practice became normalized in the practice of states, accepted unquestioningly so, and gave enormous cover to many states to pursue strategies of securitization, quashing dissent, limiting the exercise of fundamental rights without any questions being asked. But it's 20 years, and I think states have to start asking themselves the really hard question about what does that practice of 20 years of license give? What it has done, in my view, is that it has weakened democracies. It has weakened the rule of law across the globe. It has made us less safe across the globe. And it has certainly ensured that the kind of thriving and vibrant societies where civil society is understood to be an organic part of what makes a society whole, that idea is being destroyed by the practice of states. And this is really a time for states to stand up and be counted, for states who have had long histories of serious practices of violations. And those states are going to come under pressure. And I think that because the tide is fundamentally shifting, because we have a greater awareness that we are not safer when we eliminate the possibility of practicing fundamental rights by the invocation of the mantra of terrorism, and that we are not more secure by the invocation of that mantra, and that the collective security of states is not advanced by allowing states to engage in practices of systemic violation of human rights while using counterterrorism as its cover. So I'll stop there.
Thank you, Ms. Fionnuala. Please, Mr. Brian Dooley.
Thanks very much, Brian. Thanks very much again to the Cairo Institute for organising this and inviting us. I think, as with many other similar issues, you know, the diagnosis of the problem is pretty well developed. We see how awful the use of counterterrorism legislation and counterterrorism approach is, both for individual states and the consequences for civil society, and as Fionnuala points out, in a broader, more collective sense too. The remedy, of course, is always the hard bit, and generally the approach that the human rights defender mandate takes is to seek advice and really be guided by the expertise of local human rights defenders. A general instinct is to ask local human rights defenders, what do you think might work to make things better, or at least less worse? And in the context of Egypt, we're very open and welcoming of such advice. Some places, some defenders in some contexts tell us, don't make a public fuss. Don't go for the big birthday, anniversary commemoration, as Celine is putting on for Rami today. Others tell us, no, that's exactly what's needed. The international mobilization as many cities, as many countries as possible. Please, it's very valuable for us to be advised by defenders who understand better than we do what might work for them. So I just urge you, please, to keep in contact or establish contact if you haven't with the mandate, and tell us what you think will work. And it varies, I understand, case by case. But I guess that's what I'd like to say, that we want to be guided by your advice on this.
Thank you very much. Mr. Saeed Benarbia.
Thanks, Bahey. I completely concur with Fionnuala's analysis about the adverse impact of counterterrorism measures on the erosion of the rule of law and human rights, and how government used counterterrorism measures to just basically dismantle some of the very basic or foundations of the rule of law, and the independence of the judiciary as one of them. I think in the specific context of Egypt, we need just also take into account that the misuse of counterterrorism measures is a part of a wider crackdown that is targeting all the institutions that are supposed to act as a check on the government and the military, subordination of the judiciary, crackdown on civil society, crackdown on independent press, freedom of the media. And I think all these things together makes it much more difficult for the courageous human rights defenders and civil society actors and the lawyers who are still active in the country to carry out the legitimate and the important work they are doing without the necessary support from international actors. And I think it's important to insist again on the responsibility of states to hold in Egypt to account on the abuses that they are committing, including in the name of counterterrorism, and the need for more concerted effort by individual states and states acting collectively, as happened in the last session of the Human Rights Council, to maintain that pressure and to ensure that Egypt is complying with this obligation under international law. Thanks.
Thank you, Saeed. Ms. Celine Charles, still with us?
Yeah.
Okay. Please, if you have a concluding comment.
Yes. And I would like actually to also respond to Mr. Dooley regarding what we can do and what the human rights defenders are asking. The truth is, after Rami's arrest, we've been silent for over 6 weeks. 6 weeks during which negotiations were attempts at negotiating Rami's release were made by the Palestinian Authority, I believe as well by the French authorities, with absolutely no results, despite the many promises that were made to us that Rami will be released in 2 days, this week, next week. Despite that, nothing happened. So yes, after 6 weeks, I decided to launch this campaign, maybe also as a way to try to protect Rami, because maybe it's not gonna release him, though I hope it will, but at least I hope it's giving him some kind of protection. The problem is today that the Egyptian authorities have made releases as arbitrary as they've made arrests. And this has made the situation and the communication with its civil society as complicated as, more complicated than ever. Because personally, I don't know what I should do. It's very hard to get any response, any sign from the Egyptian authorities. Yes, today they have 5 coordinated rallies all around the world. It's after more than almost 2 years of campaigning. I'm not doing any of this by pleasure, and I wish I could stop tomorrow. But they are leaving us no choice. They are holding my husband. They can't expect us to give up on our loved ones. And so I do believe it's important for us all to speak up and to hold Egypt accountable to its own international obligations, so that Egypt can continue to being part of this international community. I love Egypt. I lived there for almost 8 years of my life. I would still be there if it hadn't been for my forced deportation. I wish I can go back there and live there and contribute to its growth and development the same way I was doing as a history, geography teacher, trying to develop an ecological school, but I was prevented from doing that. So that will be my last word. I do hope to see Rami, all my friends, all of our loved ones who are currently unjustly detained, released, so we can all be together and contribute to the development of this beautiful country. Thank you.
Thank you very much, Celine. I second your appeal, and I understand your appeal is not only for Egyptians, people, political parties, human rights NGO, but I would say, unfortunately, it is mainly for the international community. Egypt is a very exceptional case. Unfortunately, we don't have functional parliament. And also, as Mr. Saeed Benarbia and the other speakers explained, how is the Egyptian judiciary has become totally dependent and remoted by security services. In this regard, human rights defenders, which is the core of our discussion today, are treated as suspected terrorists, in addition to journalists, academics, even medical doctors who defend the health right of Egyptian people in time of COVID-19. So in this regard, the international community bears more and more responsibility, in particular with a country which its government, the president, consider that democracy in itself is a threat to national security. In this regard, I would like to remind you that 3 months ago, more than 30 states broke silence and condemned human rights crimes in Egypt through a joint declaration before the United Nations Human Rights Council. In response, the Egyptian government released for the first time 3 well-known journalists and dozens of other Egyptians who were unjustly detained for years. But no change has taken place in relation to the systematic and the institutional repression against peaceful citizens, including weaponizing counterterrorism to silence them. Unless the United Nations Human Rights Council establishes a specific mechanism to address these long-standing patterns of gross human rights violation in Egypt, the suffering of Egyptians would grow, and the more states in the MENA region and the other parts of the world would adopt Egypt's horrible model. I would like to thank you again, the 4 distinguished speakers and the attendance of this webinar. And of course, I thank you very much the NGOs which have sponsored this event and helped to happen. Thank you very much, and I hope to see you soon in more webinars for the Cairo Institute for Human Rights Studies.
Thanks very much, Bahey.
And have a great evening.
Thanks so much. Thanks,
Thank
Brian.
you.
Thanks, Fionnuala. Thanks, Celine.
Thank you.
Bye.
Have a great evening. Thank you.
Thanks, bye. Shukran, bye.